Welcome to Do It for the Case Law for Tuesday, August 11th, 2026. Visit doitforthecaselaw.com to listen to more in-depth, per-case reporting. Today's docket features 70 cases across 9 circuits. Our coverage includes criminal justice appeals with drug trafficking, firearms and sentencing issues, civil rights litigation covering employment discrimination, Section 1983 claims, and voting rights, a Supreme Court and constitutional law segment focusing on habeas corpus petitions for both state and federal prisoners, business and labor matters involving antitrust, bankruptcy, insurance, securities, and ERISA disputes, and immigration and government appeals, including agency review, tax cases, and Social Security reviews. Please subscribe to the show for daily updates. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. Today I have 17 criminal justice cases from 4 circuits. The disposition roll-up is 11 affirmances, 2 dismissals, 1 reversal and remand, 1 vacatur and remand, and 1 split outcome, leading with the changes. In the Ninth Circuit, a probationer's Fourth Amendment challenge to a suspicionless cell phone search forced a vacatur and remand because genuine issues of fact exist regarding whether the search violated constitutional standards. Also in the Ninth Circuit, a sentence reduction motion denial was vacated and remanded for procedural error after the district court issued a form order without explaining its decision. In the Eighth Circuit, qualified immunity was granted to a sheriff and county on failure to protect claims by an inmate, reversing the lower court's denial of summary judgment. Moving to the 11th Circuit, 3 cases were affirmed. Anthony Kenneth Griffin's appeal lacked arguable merit after an independent record review. Kenneth Steele's below-guideline sentence for methamphetamine conspiracy was upheld as reasonable despite a rejected role reduction argument, and Scott Andrew Hollington's convictions for prescribing drugs outside professional practice and obstruction of justice were supported by sufficient evidence. Over in the 4th Circuit, 4 cases were affirmed. Fine. Marvin Rashad Cummings' plea error regarding a mandatory minimum did not affect his substantial rights. Jacqueline Brewster's sentence following a guilty plea was upheld without oral argument. LaShawn Pulley's waiver barred most challenges to his drug and firearm convictions, and Timothy Deshaun Taylor's Federal Tort Claims Act suit against the government was dismissed for lack of jurisdiction due to the discretionary function exception. In the 7th Circuit, John Tavis Matlock's conviction for distributing heroin that caused serious bodily injury was affirmed based on sufficient evidence establishing causation. Finally, in the 8th Circuit, 2 appeals were dismissed because defendants' plea waivers were enforceable despite arguments about sentencing miscalculations. And 4 other cases were affirmed. Malachi Patton Handley's motion to suppress failed under the good faith reliance exception. James Marcus Diet was denied a minor role reduction for being deeply involved in money laundering. Stefan Verges' prior conviction qualified as a crime of violence, and Colton Rickles received a within-guideline sentence for failing to update his sex offender registration. Back to you, David.
Thanks, James. Let's turn to Aisha covering civil rights.
Thanks, David. 8 cases in this block. The disposition mix: 5 affirmances, 1 vacatur and remand on a First Amendment issue, 1 reversal and remand on qualified immunity, and 1 case where the lower court's denial of summary judgment was vacated for insufficient analysis. Starting with the First Circuit, the court affirmed judgment for travelers in a dispute over an employment practices liability policy. The insurer argued that a related claims provision backdated the first made date to a 2019 administrative complaint, meaning the 2021 lawsuit fell outside the coverage period. Moving to the 10th Circuit, the court vacated and remanded a decision involving New Mexico's Campaign Reporting Act. The appellate court held that the statute facially regulates First Amendment expressive conduct by prohibiting the use of campaign funds for charitable donations to non-523 organizations. In a separate 10th Circuit employment case, the court affirmed summary judgment for Instaltech on retaliation claims after the plaintiff waived challenges to discrimination counts in his opening brief. The 6th Circuit affirmed a Section 1983 claim dismissal against prison officials, ruling that force used during a voluntary hostage training exercise did not constitute a Fourth Amendment seizure because there was no intent to restrain. In the 8th Circuit, the court reversed and remanded on qualified immunity grounds for police officers who detained a man for 25 minutes regarding a potential child abuse investigation. The court found no clearly established law prohibited this detention. The same circuit also vacated summary judgment denial in a failure to promote case because the district court failed to conduct a thorough factual analysis of the qualified immunity defense. 2 other 8th Circuit cases were affirmed, 1 dismissing an ADA disparate treatment claim where the employer proved a direct threat based on current medical evidence, and another striking down South Dakota's 9-month pre-election petition deadline as violating the First Amendment under the Anderson-Burdick standard. Back to you, David.
Thanks, Aisha. And Michael brings us the latest on habeas corpus and constitutional challenges.
Thanks, David. 3 cases in this block. 2 affirmed and 1 dismissed. In the 11th Circuit, the court dismissed Donald Goins' appeal sua sponte for lack of jurisdiction because his notice of appeal was untimely. Although the filing date fell under the prison mailbox rule, it missed the 30-day statutory deadline after the final judgment. The court denied all pending motions as moot without reaching the merits of the habeas claim. In the 8th Circuit, Lloyd Elk's convictions for aggravated sexual abuse and witness tampering were affirmed. The court found the government met its burden to show a reasonable likelihood the victim would have reported to federal authorities given child sex crimes in Indian country fall under the Major Crimes Act. Evidence regarding prior bad acts from a second victim was also properly admitted under the federal rules of evidence. Over in the D.C. Circuit, Edward Williams' Section 2255 motion to vacate was denied. The court held he procedurally defaulted his claim and failed to show cause or actual innocence. To overcome the default, Williams needed to prove a reasonable probability he would not have pleaded guilty had he been properly advised of the mens rea element under Reeves, but the record showed he knew his predicate conviction carried more than 1 year of imprisonment. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business and labor law.
Thanks, David. 25 cases in this block. The disposition roll-up is 8 affirmances, 5 denials, 4 dismissals, 3 reversals, 3 vacators and remands, and 2 split outcomes. Starting with the movements, the First Circuit vacated and remanded Molly Cassell versus Jeffrey Wendt, ruling that a district court erred granting summary judgment in a real property dispute by applying unsettled Massachusetts law on whether a divorce decree extinguishes a creditor's interest in tenancy by the entirety when the non-detenter spouse gets the property. In the 10th Circuit, Wildcat Coal versus Pacific Minerals was split. The court reversed a lower order requiring a full historical royalty recalculation because a 36-month protest provision barred challenges to payments between 1986 and 2015, but affirmed that credits could offset future obligations. The 11th Circuit vacated and remanded Robert Martin versus Eric Bischoff regarding shareholder transfers, holding that while the 6-year statute of limitations bars a breach claim, it does not validate the underlying transfers as compliant with agreement eligibility requirements. Also in the 11th Circuit, Martin Renfro versus USAA was split. The court affirmed summary judgment on bad faith but vacated and remanded the breach of contract judgment for a new trial because Alabama law enforces an innocent insured exclusion barring coverage for intentional acts by any insured. The 9th Circuit granted review and vacated Rolando Calderon versus Todd Blanche, finding the Board of Immigration Appeals abused discretion in denying a Convention Against Torture motion to reopen without properly evaluating independent documentary evidence of past persecution.
Chianu Lee versus Todd Blanche was also remanded. While the court affirmed an adverse credibility finding, it held the agency erred by failing to assess whether church and family letters could independently establish past persecution without relying on the petitioner's testimony. The D.C. Circuit reversed Friends of Animals versus Martha Williams, holding that the Endangered Species Act does not authorize treating a species as endangered based on similarity of appearance if that species is already listed. Moving to routine outcomes, the 10th Circuit affirmed Homey Technology versus the National Association of Realtors, ruling antitrust claims were barred by the statute of limitations because they accrued between 2015 and 2019, and affirmed in re Zachary Rusk, dismissing a pro se brief as frivolous for failing to cite authorities. The 11th Circuit denied petitions from Florida East Coast Railway versus the Federal Railroad Administration challenging the crew size rule, finding the agency acted within its statutory authority under the Federal Railroad Safety Act of 1970 and did not act arbitrarily or capriciously in requiring 2-person crews based on qualitative safety evidence. This denial applies to multiple consolidated petitions by railroads and associations. The court also dismissed Mount
Holly Insurance versus H&M Builders for lack of jurisdiction because the underlying case was settled and moot, and the order lacked necessary injunctive qualities. In the 4th Circuit, Caitlin Trimble versus Entrada was affirmed. The court held an online arbitration clause unenforceable under Maryland law due to a lack of mutual consideration because the company's change clause granted it unfettered discretion to modify terms. The 8th Circuit affirmed Berkeley National Insurance versus Brown Newtone, ruling there was insufficient evidence of a manufacturing defect for a strict liability claim. Finally, the 9th Circuit affirmed 2 securities cases, Kalin versus Resonant and Hawk versus Figs, dismissing class actions for failure to plead loss causation or false statements with the particularity required by the Private Securities Litigation Reform Act and Federal Rule of Civil Procedure. 9.5b. Back to you, David.
Thanks, Maria. Let's turn to Raj, covering immigration and government.
Thanks, David. 16 substantive cases from the 1st, 8th, 9th, and D.C. circuits on my beat. The disposition mix includes 2 reversals or remands, 1 vacatur, and 13 denials or affirmances. First, the First Circuit vacated and remanded Ishmael Koigor Bangs against Todd Blanche. The court held that a New Hampshire conviction for retaliation against a witness does not qualify as an aggravated felony involving obstruction of justice under federal law, meaning the petitioner is not deportable based on that prior conviction. Next, the 8th Circuit reversed and remanded Nate Menigtala and Jaya Menigtala against the Commissioner of Internal Revenue. The court ruled that the 90-day filing deadline for tax court petitions is a non-jurisdictional claim processing rule subject to equitable tolling, applying the clear statement rule from the Supreme Court's Boekler decision. Moving to the Ninth Circuit, the court affirmed dismissal of Grigory Duralev against the United States in a Federal Tort Claims Act suit regarding unlawful arrest and detention, finding most claims barred by the 2-year statute of limitations. The Ninth also affirmed qualified immunity for state officials in Hansen against Ferguson, dismissing vaccine mandate challenges because free exercise and due process rights were not clearly established at the time. In immigration matters, the Ninth Circuit denied review for Blanco Cardona against Blanche. Manictala's case aside, finding substantial evidence supported the board's denial of asylum and Convention Against Torture claims due to lack of past persecution and fear of future harm. Carlos Flores Hernandez against Todd Blanche was similarly denied. The court found no compelled conclusion that he faced likely persecution in Mexico after resigning from police work 10 years prior. Cervantes Montoya against Blanche was denied regarding a second motion to reopen, which was barred as a numerically prohibited attempt. Florinord against Blanche was denied based on an adverse credibility finding driven by inconsistent statements and omissions. Loza Botello against Blanche was denied because the harm suffered appeared motivated by economic theft rather than a protected ground. Maria Meraz Espindola against Todd Blanche was denied as the murders of her husband did not constitute past persecution against her. Mateo Joaquin against Blanche was denied for failing to establish she was unable to leave a domestic relationship. And Pamela Ocho Morocho against Todd Blanche was denied because her attacker targeted her for money, not her membership in a social group. The Ninth also affirmed the denial of Social Security benefits for Stephanie Ellis against Bisignano and Zachary Yandrich against Bisignano, finding substantial evidence supported the administrative law judge's conclusions regarding medical opinions and residual functional capacity. Finally, in the D.C. Circuit, City Utilities of Springfield, Missouri against the Federal Energy Regulatory Commission was denied as FERC's reclassification of transmission facilities was not arbitrary. The court vacated and remanded the Coalition for Humane Immigrant Rights against Marquayne Mullen, holding that the district court lacked jurisdiction to stay an immigration memorandum because plaintiffs failed to show redressability given existing regulations authorizing expedited removal. Back to you, David.
That brings us to the end of today's edition of Do It for the Case Law for Tuesday, August 11th, 2026. We want to thank our reporting team for their hard work. James Taylor with 17 cases, Aisha Johnson with 9 cases, Michael Reeves with 3 cases, Maria Santos with 25 cases, and Raj Patel with 16 cases. Looking at the docket as a whole, we saw 1 reversal or remand, 32 affirmances, 15 other dispositions, and 22 dismissals. The single reversal and remand stands out as the most significant development of the day. Several appeals were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe to stay informed and follow us for daily updates.